Good morning, Ms. Menon.
Commonwealth versus David Cohen, SJC-10462 with SJC-10486.
Good morning, Ms. Sibison.
Good morning, Your Honor. May it please the Court, I'm Wendy Sibison, and these are two separate appeals, each with different and important issues. The principal appeal is my client's direct appeal, an appeal from the denial of a motion for a new trial, in which he contests convictions for offenses arising out of his actions as a police officer and trying to get a man named Tim Hills to pay back money that Hills had defrauded from a man named Peter Marinilli, who also was Cohen's client as a lawyer. I'd like to note up front that Cohen was acquitted of conflict of interest in these transactions. Unless the Court has questions, it's my intent to rely on my brief for all issues other than the Sixth Amendment right to public trial. The second appeal is from the decision of the county court vacating a stay ordered by a single justice of the appeals court. And I've asked the clerk to let me know when I have 4 more minutes in my argument. Permitting any part of a criminal prosecution to take place out of the presence of the public and the press violates a fundamental constitutional principle discussed in Waller versus Georgia.
Just by way of background,
Yes, Your Honor.
The defendant raised his concerns about the courtroom being closed on the 4th day,
That's correct, Your Honor.
but the signs were up on the 1st day.
That's correct, Your Honor.
His family was sitting in the courtroom throughout.
Several members of the family.
Why didn't he complain on the 1st day?
He testified at great length, Your Honor, that he did not know about the sign until the 4th day. Defense counsel
He didn't see the sign?
did not see the sign.
His family didn't see the signs? Nobody saw the signs?
That was not an issue. Whether defense counsel knew about or saw the sign, he testified very clearly. He was out, I'll say, Monday and Tuesday he was in court.
He testified to that.
Yes, Your
The
Honor.
judge did not accept that.
The judge,
She thought it was a strategic move on the defendant's
let me
part.
talk about the evidence about that, Your Honor, since you're raising it.
Well, it was her finding of fact.
She didn't explicitly discredit his testimony. There was a problem here, and this is not in the briefs because I hope we didn't have to go into it. When Officer Sullivan was testifying, and he said he excluded the public throughout jury selection, he suddenly said, in a non-responsive answer, this is at the motion for a new trial, that he told defense counsel on the 1st day of jury selection that he was going to put the sign up or close the courtroom. I can't remember which. And defense counsel who's questioning him went, wait, what? That didn't happen. So then defense counsel, in order to contest that testimony, had to withdraw during the Rule 30 proceedings. New counsel was brought in so that he could testify as a witness and say that never happened. Then, and at that point, we moved to recuse the trial judge because now she was being given the task of choosing between the credibility of her lobby officer, who for, as far as I know, a couple of decades, had been the person protecting her safety and security every single day in that courtroom. She had close professional relations with him, and the credibility of defense counsel, with whom her relationship was at best cordial. There had already been a motion to recuse that had been denied early in the trial because of personal relationships between the two. So the judge was kind of in a quandary. She couldn't make a judgment call between and find that her officer was telling the truth and Mr. Egbert was lying without raising this issue of her recusal. She had refused to recuse herself. So what she did was she skirted around it and at the end said, it defies logic that counsel wouldn't have seen the signs. She didn't make that credibility judgment that Your Honor is suggesting. All she said was at the very end, it defies logic that he didn't see the sign. And I'd like to point out something I saw.
And she also concluded it was a strategic.
Yes. Now, let's talk about strategic. I'm an appellate lawyer. There's no strategic reason, if you know of an appellate issue, to wait for 4 days in the middle of jury selection to move for a mistrial. You've got a problem. You say, there's a problem. I'd like to raise an appellate issue. I'd like to put my objection on the record. This courtroom is closed. Move for a mistrial. 5 minutes into it, if he knew about the sign. There makes no sense to say that he would wait for 4 days to sort of log an appellate issue. What he did was very vociferously ask for a mistrial. He didn't say, I'd like an appellate issue. He said, I want a mistrial.
Was a mistrial the appropriate remedy?
Yes, it was, Your
As
Honor.
opposed to just beginning the impanelment over again?
Yes, Your Honor. I cite a case law in my brief somewhere that says that for purposes of the Sixth Amendment right to jury trial, a trial begins with jury impanelment. So mistrial was absolutely the appropriate remedy. And if Your Honor likes, afterwards I'll find that place in my brief. No, it was, of course, the appropriate remedy. And he asked for it. He asked for it vociferously. He moved for mistrial many times. This was not a pro forma objection. Please make note my objection for the record. I just want an appellate issue here.
Well, many times on the same day, or am I wrong?
Yes, correct.
Yeah, so we're talking...
Well, starting with he was out on Wednesday, sick. He got in that morning. Then he saw the sign on the door. He did some investigation. He describes at great length in his testimony exactly what he did. Then he found out that members of the defendant's supporting team, supporters, his friends, had been excluded. He brought a couple of those names to the judge. He did more investigation. Later that day, he brought 9 names. This was not a pro forma objection. It was a very extended effort.
And the judge ordered that people should not be excluded.
The judge
Thereafter.
made no such order. There is
Well,
no
she finds that she did.
Yes, that's true, Your Honor. Well, you can search the record in vain for any such directive. There is no trial record of that directive.
Is there anything in the trial record that after Mr. Egbert brought it to the attention of the judge that there were people excluded? I understand the person that got
Yes.
ejected, but
Yes.
there were also
Well,
people
both
excluded?
members of the press said they were there every single day of jury selection waiting to get in, and that the sign was up, actually. Both of them testified. Well, no, excuse me.
And after she said the
Excuse me.
sign went,
One
should
of
come
the
down?
2 reporters said the sign was up the first day. It was up every day of jury selection, all 5 days through Monday. The other one wasn't sure when it went up and when it went down. But both of them said they couldn't get in all 5 days of jury selection. Those are members of the press. They had no axe to grind in this case. They didn't even know their rights.
There was a section set aside for the press, and they never
Yes.
even identified themselves as press.
Well, one of the 2 teams had been sitting in that press section in the motion session before, the pretrial motion session before jury selection began, and he testified that a court officer came over to him, and I believe that this was uncontested, and said, "You're going to have to leave during jury selection." So he was with a team. They had a camera. He had his editor with him. They didn't have press pass in giant letters around their neck. They were sitting in the media section, and were told they'd have to leave during jury selection. That was before that court officer had even an opportunity to assess the amount of space there'd be in the courtroom that afternoon when jury selection started, because this is a policy. Everyone agreed. It's a policy. People don't come in during jury selection.
Including press? That's a policy?
Well,
I didn't see a finding of that.
That's true, and I can't. I mean, the testimony of the court officers was that it is the policy to exclude the public during jury selection, and that if the press comes in at the beginning, they can stay, but they can't just go in after the courtroom is closed. That was the testimony.
Ms. Simberson, is
Yes.
there any significance to the fact that what was going on was individual sidebar voir dire?
I'm glad you asked that question, Your Honor. Okay, the Commonwealth makes...
So nobody could hear what was being said
Yes.
by any of the prospective jurors
But let's
as they
look-
came up to the sidebar.
I understand the issue. This is a point that the trial judge has made and also that the Commonwealth has made. But let's talk about what happened right before that sidebar voir dire happened. In open court, every single member of the veneer was asked the critical questions that caused that screening. That's where they had to tell the truth. Are you aware of any bias?
All they had to do
Yes.
was they didn't have to say a word.
No. Here's the way it went. They're all sitting there. The judge asked the serious questions. Are you aware of any bias that might influence your decision in this case? Someone that you had to say yes by raising your hand. You had to show who you were. And that was in open court, and the public wasn't there. The watchful eye of the public wasn't there to add that weight.
You don't count the family as public? I mean, they're citizens. They're not...
I'm not aware of any case that says that 3 members of a defendant's family constitutes the public and the press for purposes of the right to a public trial.
And you're saying there was no press there at all?
I am saying there was not a single finding by the judge and no testimony that there was a single member of the press present at any time during jury selection. That's what I'm saying. Even the judge made no such finding.
Now, as I read the judge's findings of fact, she says that it is the practice at Norfolk Superior Court to exclude the public, other than the media, from jury impanelment if there is no room for spectators. However, where there is room, spectators are placed in the seating areas on the sides of the courtroom.
Yes.
What's wrong with that?
Well, that was not the testimony of the court officers. Let's start with that. That was
Okay.
also not what happened in this case.
Okay.
On Thursday, when defense counsel said, people are being not allowed in the courtroom, and there's tons of room here, what's going on? The judge said, well, that's true, and this is the actual key to this case, if I may say so. At page 89 of the appendix is where defense counsel first moves for a mistrial and says there's a sign here, and the judge says, oh, that sign. Now, by the way, the idea that the judge didn't know about the sign cannot be sustained this way. She said she didn't see it, but she didn't say she didn't know about
Well,
it.
the idea that defense counsel didn't see the sign is difficult to sustain as
Well,
well, since
but-
he walked in and out of that door
But
countless times
one
every
of the
day.
one of the court officers says that door is often open. So unless you've got a court officer say, well, let me say this, Your Honor.
What about
Let me,
the,
no, I want to, please.
Sure.
The judge did not find that defense counsel was not telling the truth. She only said it defies logic, and I don't find that to be a finding of fact when there was actual contrary testimony, one way or the other, about whether he saw that sign. So that was an evasion. And secondly, I know it's wrong for me, Richard Egbert was the most honorable person on the face of this planet. He would never have lied under oath. Sorry. I shouldn't say that, but I'm going to. So if he said he didn't see the sign, he didn't see the sign. And the minute he saw it, he was there in everyone's face saying, this is wrong, this is a public trial, my client hasn't waived it, we want a public trial, we want a mistrial.
All right. I'll ask the Commonwealth this. Did Mr. Hallamore testify at the hearing?
Mr. Hannamore presented an,
There's an affidavit.
Hannamore versus, there's two people, Hallamore, I think you're referring to, Your Honor.
Yes, I am.
He was
Hallamore.
someone who was sitting out in the hallway.
Yes.
Yes. And
Every
put
day.
in-
He was a witness. He was sequestered. So
Yes, and he
sitting
was
there.
out in the hallway watching, and he said that he saw people going in and out. But he never said he saw a court officer let anyone in, not once. And on a side matter, I want to get back to actually the evidence that the judge was really not doing what she was supposed to do here. When that man named Rapoli, and this is relevant to Mr. Hallamore, Your Honor, when that man named Rapoli turned out to be a friend of the defendant's, was kicked out in open court, and Mr. Egbert said, why is this guy being thrown out? And the court officer said, well, he's a police officer. And Mr. Egbert said, well, why can't a police officer be here? And the judge just let it happen. Just let it happen. And then later, Mr. Egbert came back and said, Your Honor, he wasn't a police officer. He was a member of the defendant's family. The judge didn't do anything about it. She couldn't even remember it had happened. Then, at the motion for a new trial, the officer said, well, I kicked him out because he was wearing police pants. Well, actually, Mr. Hallamore identified the man who was kicked out and said he was wearing Bermuda shorts. And by the way, Mr. Rapoli testified he'd come right from his sports club that he owns in dress shorts. So that whole police pants, that he was a police officer, that had nothing to do with reality.
Yeah, Mr. Hallamore testified that he was there on June 18th, sitting there, actually talking, I think, well, I don't know if he testified to this, because all I have is his affidavit.
Yes, affidavit.
And that he was talking to Attorney Krauske. Attorney Egbert came up, they had a discussion, and Attorney Krauske pointed out the sign and took a picture of the sign.
Well, the judge
on the first day of
the judge
impanelment.
didn't make any findings that was true. And the judge made no findings crediting that statement, and it was in direct contrast to Mr. Egbert's testimony that the first time he learned about that thing, he called Mr. Krauske over and said, take a picture. Mr. Krauske took a picture with his cell phone. That photo, Mr. Krauske testified at the hearing on the motion for a new trial. That's my photo. There's the date stamp on it, June 21st, not June 18th. And he said, my cell phone has always been dead. I think it was his cell phone. Maybe it was his camera. I'm sure. Sorry. There was contradictory testimony, and the judge didn't resolve it, Your Honor.
Ms. Sibison, your
Yes.
total time is up. You have had a lot of questions. If you want to address briefly the stay issue, you can do so.
I do want to remark on the stay issue further, but if the court has more questions about this, I'm eager to answer them, and I will continue.
Is it critical to your argument that we find that the judge knew that the sign was up?
Well, it's not critical. It's important.
Okay.
Because,
If it's not critical, let's assume for the moment that we credit what Judge Dorcher-Carr said, that she was not aware that the court officers had closed the courtroom.
well,
You smile, but that's what she said, and I'm not convinced that are you going to find four of us who are going to find that she was not credible in her findings, but assume for the moment that it was inadvertent. Does that change the analysis?
no, of course not. The case law is that if court officers do it without the judge having any idea of what's going on, the Sixth Amendment right is equally implicated. I do, nonetheless, and no, it doesn't matter. I still have to insist that at page 89 of the appendix, page 7 of the fourth day of trial, Mr. Egbert says there's a sign up there, and the judge says, the motion is denied. No one has been denied access. That sign, there's a particular issue of people coming and going through. And then she gives all the reasons why the sign's been up. I'm sorry, that does not bear scrutiny. She doesn't say what sign. She says, yeah, that sign. I didn't, she says, if anybody wanted to come in, I'm sure it would have been brought to my attention and I would let them in. She acknowledges on the fourth day of trial that people needed to ask for permission to get in the courtroom. She acknowledges it.
Ms. Siverson,
And there's no notice anywhere on the record that that was a condition.
unless there are further questions, if you want to take a couple of minutes to address the stay issue, you can.
Yes, Your Honor. Thank you so much. This is an also important issue to Massachusetts jurisprudence because it implicates under what circumstances are people who are likely to have their convictions overturned going to be required to be serving their sentences. And by the county court's decision, anyone who may have their conviction overturned, who may have a meritorious appeal, is stuck in jail if the trial judge denies a stay without giving reasons, unless he can show that she abused her discretion. Almost impossible hurdle to overcome.
Well, are you saying then that the appellate judge does a de novo
Yes.
review?
Yes, I
from
am, Your Honor.
scratch?
That's the law of this court.
What
law
about
of this-
what does Hodge say?
Well, Hodge says that where a judge has granted a stay, then the Commonwealth can appeal.
Doesn't Hodge say that the trial judge's conclusions on security issues are issues of fact?
Under the circumstances where the trial judge has granted a stay and the Commonwealth appeals, and Hodge goes on to say the single justice may but need not exercise independent discretion under those circumstances. It's a completely, well, may or may not be a different story. I just want to tell this court what the state of the law is on where the trial judge denies a stay. In Commonwealth versus Aviles, this court reaffirmed the proposition that where the trial judge has denied a stay, each judge or justice has the power to consider the matter anew, exercise his own judgment and discretion, and the reporter's notes to new Criminal Procedure Rule 31, effective next month, squarely state that Aviles is the applicable law where the trial judge denied a stay, and then says that Hodge is the applicable law where the judge grants a stay. So it cannot be, and Commonwealth versus Allen says it very clearly, that it's particularly important that a defendant have de novo review where the trial judge has denied a stay, because otherwise the trial judge is going to, whose own rulings are being challenged as to the propriety of the trial, who's being challenged in terms of the fairness of the trial, is going to be able to make sure the defendant stays in jail until his conviction's reversed.
There were no findings in any event here.
No
right?
findings. And as I pointed out, this trial judge had never found this man to be a security risk, not once. And Judge Zakura looked at the record, as this court can, and you can see he's not a security risk. No one's ever said he is. So I would ask this court right now to forthwith order my client released from jail on the conditions that Judge Zakura found were appropriate without any remand to the trial judge on his own recognizance.
Thank you, Ms. Siverson.
Thank you.
Good morning, Ms. Glennon.
Good morning. May it please the Court, Stephanie Martin Glennon, on behalf of the Commonwealth. With me is George DeBoer, who was the lead trial prosecutor in this case.
Ms. Glennon, Ms. Sivison has a comment in her brief, and it seems to me to be fairly well taken. It does seem to me that more than half of your brief is in footnotes. And I'm just wondering why you chose that mode of communication.
I think it may still be a bad habit from law school. I apologize if the footnotes, I was trying to use those to elucidate things. There was such a body of material to cover that I apologize for that, if that's a problem with the flow of the brief.
Well, there are some of us who like many opinions with many footnotes, which is not always appreciated by everybody either, so I didn't have quite the same response as Justice Watsford. So be that as it may, as long as it's not an attempt to get around the page limitation, which I'm sure it wasn't.
So what do you say the record says with respect to whether this proceeding was closed, partially closed, knowingly closed?
I say essentially, Your Honor, that there's no basis for finding it closed under Waller, both by its terms and its reasoning. There would be a closure only if, for constitutional purposes, only if there was a wrongful closure of public proceedings of constitutional import without a defendant's assent. And it's the Commonwealth's position that in this case, not one of those factors was present on the record and given the judge's findings.
Are you saying that closure can only occur if the judge actually orders a closure?
No, but I'm saying it does have to be wrongful, and there does have to be a public proceeding within that's of constitutional import for there to be a closure and for Waller analysis to apply.
And jury selection isn't a public...
I'm sorry, Your Honor.
Go ahead.
I was going to say, doesn't that beg the question then, what's a wrongful closure? What do you look at? Do you look at what's going on in the courtroom? Do you look at who's excluded?
Well, yes, and you look for, if there's justification for, if a room is full, that alone is justification as a courtroom management. If every...
Yeah, would you agree with me that the record is at best mixed on whether the courtroom was full at every minute that there was, every day that there was closure?
Well, if I could backtrack a step, I mean, the record here is clear that there was, at very least at all times, a considerable public audience to a sidebar voir dire that was taking place at sidebar because the defendant conceded he wanted it there for strategic reasons to screen and to select the fairest and most receptive jurors. So
I can understand that as a statement of fact. I don't know whether it's a considerable public presence.
Well,
but what difference does it make if it's sidebar or not sidebar?
That is the threshold at which the defendant's claim has to fail. It makes every difference in the world that this was a sidebar proceeding, because in Commonwealth versus Horton, this court held that where a defendant strategically even acquiesces in a sidebar, in a non-public voir dire, in that case, it was a voir dire, individual voir dire held entirely outside a public courtroom. And that was determined by this court not to be a public trial violation, even though no spectator could have had access to that. The voir dire in that case took place in a jury deliberation room. Here it was in a public courtroom. But if a voir dire can be taken completely outside of a public courtroom, a public forum, where no spectator can attend it, and that's not a Sixth Amendment violation, then how could it possibly be a Sixth Amendment violation if a defendant is having this procedure done at sidebar?
Aren't you conflating two issues? I mean, there's a public courtroom part of this, as Ms. Sivison said. People have to answer questions, maybe by their hand, but there's a public courtroom part of this, and then there's a voir dire. And I don't think that the complaint here is certainly isn't only about the voir dire, and I'm not even sure it's at all about the voir dire part.
Well, I think Waller necessarily conflates these aspects that all have to be present for there to be a violation. That is, if any one of them is not true, if there is a public audience, if there is an adequate public audience, that's not a structural error, as the defendant is claiming. If there is a sidebar proceeding, as in Commonwealth versus Horton, where if there is a non-public voir dire, that no spectator could attend or hear anyway, that's not a public trial violation.
Ms. Glennon, let me just go back to Horton. What do we make of the statement where the court, Justice Sussman Lighting, said, we agree with the defendant that individual voir dire should be conducted in open court. I take that to mean not that you can't have it at sidebar, but that it shouldn't have been done in a jury deliberation room, if you read the whole context of that.
Right. I think that was to distinguish precisely that which takes place completely outside a public forum, which is certainly would be a much greater closure, yet wasn't found to be a public trial violation.
Well, it wasn't found to be an
what takes-
ineffective assistance of counsel claim for failure to object. So it wasn't. So it was. It in fact was under a substantial likelihood of a miscarriage of justice. That is not a holding that there's no constitutional violation, anything but.
But there was determined to the defendant's mere acquiescence, and that was considered to be a waiver given the objectively reasonable benefit that a defendant would derive from not having voir dire being publicly spoken in a courtroom. What I'm saying is that it's an individual criminal defendant's choice. If he does elect that
He
potential
may elect to have a
jurors...
sidebar, but he doesn't elect. But what the court is saying, that should nevertheless take place in an open courtroom. And I think that the press would say, if nobody else, what one can observe in an open courtroom, even when, and having been called for jury duty, and maybe this is outside the record, watching people being called up for sidebar and watching what's going on is very much a public process, even if you can't hear the colloquy between the judge and the individual prospective juror.
Your Honor, I agree. And in this case, it was a public process. The defendant's family members were there at all times. The co-defendant's family members also were there.
Let's agree that you're saying it should be a public process. Then the issue is, was the presence of 3 family members in the face of a sign on the door which says, wherever the sign is, no entry or whatever it said, jury selection, do not enter. It meant that anybody other than the 3 family members.
Well, Your Honor, there were a great deal more than 3 family members present in the courtroom at all times. At the beginning, at the outset, before impanelment even began, the trial judge accommodated everyone the defendant asked to be accommodated, and knowing that the public gallery was going to be full, given the size of the incoming Venari panels, she made sure that the defendant's family members, everyone he asked to be accommodated, were seated inside that courtroom as a public audience.
I'm not quibbling about the number of people. The question is it public if whom the defendant wants in, as opposed to, and that, I mean, I understand if anybody else is excluded.
Well, she found that other members of the public also were present, and again, as the co-defendant's family members were additional spectators. As to this defendant, in addition, here there were another 358 watchful eyes on the process inside that courtroom because of the enormous member of the cross-section of the community that passed through this courtroom and did cast a public eye on the proceedings. So nothing secret about this.
Has that ever been viewed as sufficient public presence if other members of the public are fully excluded?
Well, Your Honor, I could only find 2 cases in which that was even raised. One is Brown versus Kuhlman, which is a Second Circuit decision in which the court did advert to the presence of jurors and alternates as members of the community. Also, there's a pending court on appeal in the Second Circuit out of the District Court in Connecticut, People versus Loria, where the court also held that when the public gallery was filled with jury members, a large incoming panel of approximately 100 jury members in that case, that was deemed to the defendant's strategic benefit, and those were considered effectively members of the public, a cross-section of the community that it benefited him to have in the courtroom. So I would say it has not, that I could find, been addressed in any other case. But
back to the sidebar voir dire. Before sidebar, there were the general questions that were put
Yes.
to. Now, what about that point that Ms. Sibison made?
Yes, Your Honor, I did want to get to that. Under Commonwealth versus Gordon, you've set forth a distinction between the constitutionally significant portions, and this goes back to my introduction about Waller. There are constitutionally significant portions of a jury voir dire, and then there are portions which have never been deemed of constitutional significance. For example, eyeballing prospective jurors under Commonwealth versus Campbell is not even a right of constitutional significance for the defendant himself. So how could he possibly have a Sixth Amendment right to have third parties conduct the same constitutionally meaningless visual appraisal? Gordon really differentiates those portions which are of constitutional import, and those essentially are the individual voir dire questions as to a potential jury's qualifications to serve. And even some oral exchanges, like hardship inquiries, are not considered of constitutional dimension, and therefore even a complete exclusion of the public from those would not implicate Waller and would not implicate
So a
the Sixth
general
Amendment
question,
right.
are you aware of bias, would not be considered?
I think raising one's hand, there's no case that has held that would be an act of constitutional import for yet additional spectators. And of course, in this case, there were ample spectators. This was never closed, and there was never a closure order. There was never a motion to close. And if, to the extent that the defense knew that there were,
in your view, how did the sign get up there? And
the court officer put it up there precisely because of the overcrowding and to prevent jury contamination from yet more people wandering in and sitting down among the jurors, the potential jurors. That made it a court management issue. For example, Your Honor, it's clear that a court officer could post a do not enter sign on a courtroom door during a jury charge, and that would be merely to avoid the possibility of distracting the jury during the charge. That's a court management issue and an issue of protecting the jury. It's not a matter of imposing a cloak of secrecy over the proceedings. It's that the jury and accordingly the defendant's own right to fair trial has to be protected. So courtroom management actions which are taken to preclude overcrowding or contamination or disruption of the jury or distraction of the jury simply are not a closure.
Well, I won't even give it a preface. What's the level of scrutiny that we should apply to a case like this? It's just a management thing, so we just brush it over, or we take a hard look at it, or we, this is just another one of those. The impression that you are leaving me with is this is just a little management issue. The judge may or may not have known about it. The court officers do it. When they're going to, it looks as if there's going to be overcrowding. They stick up a sign that says "Do not enter."
Well, there was in fact the trial just found, and defense counsel knew at the outset that the public gallery would be full.
You said defense counsel knew at the outset. As you know, Ms. Siverson says there is no finding.
The trial judge did find. There is expressly a finding that defense counsel was aware at the outset. I believe it's at page 4 of the addendum that defense counsel, and that's the only way to explain why defense counsel would ask for the family to be accommodated inside the bar enclosure, inside the courtroom.
If the courtroom is in fact small, it might be that the defense counsel does that without knowing it's going to be closed. What's the finding? Because Ms. Siverson is so insistent that there was no finding.
Addendum page 3, Attorney Egbert was aware that the public could not be accommodated in the spectators gallery because of the large number of jurors to be called, and he wanted to make special arrangements for the defendant's family, which the court then made. There's no way to explain why the court would have been making these extra seating arrangements inside the bar enclosure if defense counsel wasn't fully aware that the public gallery was going to be filled.
And that was because there were 358 prospective jurors?
That's because the trial judge was aware at the beginning. That's also reflected in her finding that due to the nature of the case, the atmosphere of the case, in which she had witnessed already in the courthouse in terms of pretrial motions, that this was a case that was going to need a huge number of potential jurors.
Did the panels come into the courtroom? How many panels came at once into the courtroom for the impanelment?
Well, one panel came at a time. There were very large panels at the outset, and Your Honor, the defense counsel, knowing the huge size of the panels that were incoming, he didn't ask for smaller panels.
Okay, How big were the panels that came in?
The first one, it was in the 90s. The second one was of similar size. Wednesday, they were slightly smaller. All of the numbers are actually reflected in the trial judge's findings.
Now, I understand when you say in the 90s, they were called to the courthouse. I'm just asking, did they all come
They
en
came
masse
in
to
en
the
masse, yes,
They
into
did?
the
Okay.
courtroom. And so room had to be made to sit them for the initial, the non-individual voir dire.
It seems to me, Ms. Glenn, and I would have to look at the record very carefully, that it might well be that one anticipates that it'll be difficult to find seats for the members of the family, so you ask the judge to accommodate. Whether or not that translates to the judge knowing or defense counsel knowing that there was a sign on the door that said, do not
Oh, no,
enter.
I'm not saying, I'm saying that defense counsel was fully aware that the public gallery was going to be filled. Certainly, the
Oh, I
trial
thought
judge, as
you
a
were
matter
telling
of
me that
credibility,
that
was
defense
entitled.
counsel knew that there was a sign on the door.
Certainly, the trial judge, as a matter of witness credibility, having heard all three defense lawyers testify at the motions for new trial, was entitled to find, and she found not only that it defied logic that defense counsel so attuned to the nuances of closure law that he had litigated issues of constructive closure before, that he would not have noticed a do not enter sign, nor would his attorney client, nor would
No,
the
I
other two
understand. So you're
defense
pointing
attorneys.
to the same quote finding, which Ms. Sibison says is not a finding. It says it defies logic. That's not a finding.
And the trial judge also found, of course, and the record absolutely establishes that when defense counsel said he had objected all day, every day, and asked for alternatives and moved to remove the sign, that simply didn't happen. There was a very narrow objection that the trial judge found he held in abeyance for strategic reasons. Should I move on to the stay issue, Your Honor?
Well, your time is up, and I don't know if there are any other questions from the court. And yes, and you've got a couple of minutes to address the stay issue as well.
Thank you, Your Honor. Despite the procedural history of the stay application in this case, I think it's fairly simple that jurisdictionally this stay application was over in September of 2007 when an appeals court single justice ruled that the trial judge did not abuse her discretion in finding that immediate commitment was appropriate for this convicted felon convicted of felonies against 3 separate civilian victims, including attempted extortion and witness intimidation. That was a binding ruling that the defendant did not challenge on appeal, that he failed to show that on all the information known at sentencing, no conscientious judge acting intelligently could honestly have determined immediate commitment was appropriate. And at page 4 of the addendum to the single justice appeal, you'll see the single justice's detailed findings as to why the trial judge had not abused her discretion.
But he reversed himself later on, didn't he?
Didn't Judge
No, I'm talking about on September 11th, he made that finding that the trial judge
who's
did
the
not
he in that
abuse her
sense?
discretion. There was never
That was Judge Sikora.
that was Judge Sikora
but
on
didn't Judge
September
Sikora
11th of 2007.
But didn't he later on change his position?
Yes, Your Honor, and it's our position he never had jurisdiction
Couldn't
to
do that.
revisit the matter,
Uh-huh.
because following that, the defendant selected his own standard of review, because under this Court's decision in Sang-Hwa, he had 2 choices, at minimum 2 choices. He could have sought an appeal to an appeals court panel and then, if necessary, pursued further appellate review from this Court, or he could have done what he chose to do, which is to bring a 211-3 to the county court, and this is in September of 2007. In September of 2007, by choosing to bring a 211-3 petition and not appealing to a panel of the appeals court, the defendant under Sang-Hwa decided that the standard of review that he was going to get for that application was summary review for errors of law. And on September 13th of 2007, a single justice of the county court of this court denied the 211-3 petition. It's the Commonwealth's position that no lower court then had any jurisdiction to revisit
You
the
did not
matter.
appeal when the appeals court revisited this issue, did you?
It wasn't our appeal, Your Honor.
No, when Justice Sikora entered the stay.
When
Is that what you're talking about?
Yes, that's what I'm talking about.
in 2007, Your Honor?
No. When Justice
Thereafter.
Sikora entered
In
the
2009, we applied to
they took
a
the single
211-3.
justice.
Yes, we applied, and that resulted in the order vacating that. So, yes, we did, and this is the defendant's appeal from Justice Spina's order vacating Justice Sikora's April 2009 order. After September.
I think your time is up, and I think we
Okay.
can work out the
Thank you, Your
procedural
Honor.
ways. Thank you, Ms. Glenn.